Hi, it's Roland Jones. This is the next video in a series of videos on preference and fraudulent conveyance issues. In this case, this is a recent Court of Appeals case, 2015. The issue of the case is whether payment was made according to ordinary terms, that part of the ordinary course defense. And the facts are not complicated. The debtor purchased equipment with the goal of increasing its coal production by converting to a different system. And the contract was entered into, the equipment was provided, and the debtor paid pursuant to the contract. The payment was actually due a few days prior to an involuntary bankruptcy petition that put the company into bankruptcy. And the trustee was appointed and sued the provider of the equipment for a preference. Surprise, surprise, the defense was that the payment was incurred in the ordinary course. The debt was incurred in the ordinary course and the payment was made in the ordinary course. Trustee had a creative argument, as trustees often do, and the argument was, hey, this was a big, extraordinary new strategy by this company to use this equipment to cut costs, and it's a whole different thing that they ever did before, and so it was actually not incurred in the ordinary course, and so the ordinary course should not be available, and that was his argument. So the issue here is, are debts resulting from agreements deviating from the normal scope of business? I would say not even between the parties, but maybe just of one party. In other words, if this is not ordinary or extraordinary, or if this is extraordinary for one particular party, in this case the debtor, and can the debt be held to be incurred in the ordinary course of business? This is the applicable section, and we're going to yellow the issue we're focusing on. Such transfer wasn't payment of a debt incurred by the debtor in the ordinary course. So if the debtor never did this before, if this was something out of the blue and the debt was incurred in this new strategy, is the trustee right? Is this not incurred in the ordinary course? The court basically shot down the trustee's argument and looked at the transaction and found that even though this was the first time transaction, even though this was not usual for the company to buy this sort of equipment and it's a different strategy, it doesn't matter. It was incurred in the ordinary course. The debt was incurred in the ordinary course, and the debt was a result of arm's length dealing. That's what the court focused on. Not that it was something that was unusual for the debtor to buy, but that the transaction itself was ordinary because it was done in arm's length. Nothing weird or extraordinary about it. So the holding is, and this may be useful to know if this fact pattern comes up, is that even though the debtor was entering into a transaction or a new business or some kind of activity that was extraordinary for the debtor, even though that was the case, if the negotiation was at arm's length and if everything else about the transaction is ordinary between the parties, then the transaction can be protected by avoidance, from avoidance by a trustee through the ordinary course defense.